Hi everyone, it's Neil here from Fairway Financial, and today I'm talking with Tim Henry.
Hi Neil.
Hey, Sam, from Henry Law.
Henry Lawyers.
Lawyers. Oh, multiple. That's good. For those of you who've been following the Get Real at Neil series, this is where I tune in and tap into some of my network of people that I've met over 25 years in business. It sort of astounds me as I meet new clients and they tell me bad experiences they've had with people in the financial services world. And I think if they'd been talking to somebody I know, I just know that wouldn't have happened. So
That's right.
Tim's one of the good guys, and he's here today to talk law, estate law.
Yeah, the good types of law.
The good types.
Not the bad types.
Cool. Those who know a bit about Fairway Financial know about our financial cube, which represents the 6 sides to or the 6 aspects of financial planning as we see them. Probably if you're listening on a podcast, you can't see that I'm holding up a colourful square box. And just very quickly, it talks about income and how you're using it, retirement, meaning where you're going. When you know where you're going, it makes it much easier to come up with an investment plan. Debt is, a lot of us have it. Some people it's a noose around the neck and other people use it well. We refer to those around the outside of the cube as growing your wealth.
Okay.
And over the top is the protection plan. So that's overlaying that, looking after those things. And then eventually at the bottom,
6 feet under.
it will pass at some stage. So the estate plan is the last bit. And that's the tie-in for having a chat with Tim today.
Very good. Nicely done. Nice segue.
Thank you. So what is the Tim Henry story? Where did you grow up, and the parents used to do what?
Okay.
And
Born in Marta, over at South Brisbane.
Cool.
So South
Brizzy.
Sider.
Yeah.
I know I get a bit of slack on the north side for being one of
that's
those.
all right. You've come to the good side.
Crossed over to this side when I got married. I got married about 4 years ago now.
Yep.
So I went to school called St. Lawrence's on the south side, and then still friends with boys from there. That's an all-boys school. Sort of didn't give me the greatest way to deal with females, so it took me a long time to actually find a wife. But when I did, I settled down pretty quickly. I now have 3 children and started my own place about a year ago now.
Very good.
Yeah.
And growing up, did Tim have a claim to fame? Was there
Yeah, I was the Ducks of year 5.
Woo! Nailed year 5.
Yeah, I was good at volleyball actually.
Volleyball,
I was in
nice.
the first volleyball, which I was pretty happy about.
Yep.
I like debating, public speaking, and I was in the Lions Youth of the Year, which was a sort of thing that they did for students around certain schools, and we had to do a speech. And I did my speech on love.
Ooh, okay. What age are you?
I was year 11.
Year 11.
And the other topics were quite political and of current matters, and mine was about sort of love, schoolboy love, which was taken pretty well, but I think they were sort of wondering who are these guys from Laurie's, because they are not taking this seriously. Because the other captain of my school did it on backyard cricket. We were fairly different. But,
I think in year 11 I would have been safe with backyard cricket, and I would have left love alone myself.
Yeah.
And what led you to law? Studying.
Did you watch that show Boston Legal?
Ooh, okay.
So I like that show a lot.
You like the suits?
Yeah.
No, you're in a polo.
I try and
Henry Lawyers branded polo.
Try and wear as little suits as possible.
Yeah,
basically, the rule is you have to wear them to court. Any other time, I don't wear them. But yeah, I love Boston Legal, but I actually was obsessed with the show House, which is about a doctor. You're aware of that one?
Yeah.
So I wanted to be a doctor when I was a bit younger, but then I turned out that I wasn't very good at science and or studying for that sort of stuff. So when I realized that, I looked at my options, and law looked like the next best thing because I like debating and that sort of stuff. And I turned out my mind's much better at law than it was at science. So it's worked out for the better.
Yeah, that's cool.
Yeah.
And when you're doing law, like 5 years?
Yeah. Oh, Four
plus?
plus another year for practical training. So 5 years.
Yeah.
It's a bit of a commitment. Yeah.
When you start, I guess that it's all aspects of law.
That's right.
But then at some point you've gone into the estate.
Yeah.
Yeah.
So succession law is what lawyers call it.
Right.
But it is estates and wills essentially is what that is.
Yep.
So yeah, I did succession law actually in uni. There was a subject called succession law, and I got a 4 for it, which is just a pass.
7.
So I was pretty hopeless at it back then. I actually liked criminal law when I first started my degree. That seemed to be the most interesting. But when I got out into the real world and I did a bit of criminal law, it sort of turned out that it's not for everyone, definitely.
Yeah.
You're dealing with certain sorts of people, and it's a lot of court time and just a lot of stress. So I moved into succession law straight away. So I did while I was doing my practical legal training, I was with a criminal firm, and then they teamed me up with a prominent succession lawyer in the city, and I was with him for a long time. Yeah. And he taught me the ropes, and I haven't looked back since.
It's good to have that mentorship. I guess most professions, that's sort of the progression, isn't it?
Yeah, that's right. It's sort of you sort of find someone who seems to know what he's doing, and then if he's doing a good job, you can sort of emulate that and then move on and try and do yourself on that. Yeah, which is what's happening.
When I did economics at uni, and then I had a job at National Mutual, a big insurer, for 5 years, and then when I left there, I went and worked with a group of agents of a National Mutual. Right. And they were the ones that sort of encouraged me to get into the advice side of things. And I caught up with my old boss, like the guy who sort of taught me the ropes just recently. And I found myself just sort of mirroring him again.
Is that right?
Yeah, like it was like, wow,
The mentor.
Yeah, that's right. Yeah, all those years, like 25 years ago.
Was he proud of you?
Yeah, he was. I said, I say that now. He was telling me stuff that happened. I still say that now. But if it works, that's what you do. In my simple terms, I think of estate law, succession law, as planning for what if, and then dealing when something happens.
Yes.
So is that? Are they
different? Right. Although the word "if" I would say is probably not as relevant because you have to die.
Yes.
There's no.
But I'm thinking, yeah. Right.
You're thinking about if you lose capacity or something like that.
No, I'm thinking of maybe you get involved with two different sets of people. There's the people who are dealing with, oh, well, if I die, I should have a will and enduring power of attorney, and you talk to them about setting up testamentary trust. Yeah. But then you might be dealing with maybe the same, but also a different set of people where now something's happened. Yeah. And now we're dealing with when this has happened. Yeah. How does the estate get managed?
Right. Yes. It's planning, and then the other side is administering.
Administering. That's a better word.
So that's the way it works, and that's all I do pretty much. Is I help people plan for their future, which by future we really do mean their demise. Yep. And then after someone has passed, we deal with the administration of the estate, which is dealing with everything that person owned to try and convert it into cash or transfer it to the people that it needs to go to in accordance with the will, or if there is no will, in accordance with the rules of intestacy, which are a set of rules that are set by our government that say this is who needs to get your estate because you didn't have a will. And they are...
Do you know the stats, like who's got wills and who doesn't? Like,
it's something like 50%, isn't it?
Don't.
Yeah.
Yeah,
that's right.
Bad.
Yeah, it is bad, and it happens all the time.
Because I'm helping people with beneficiary nominations from insurance and their super, and it's like, oh, that's easy. You can fill out a form, sign it, we're done. Yeah. But it's like, what about all the other stuff?
Yeah, that's right. And even people don't even do that.
Yeah, that's right.
Yeah, super. They just do it online, and then it sort of either lapses.
Yeah. I left it to my mum years ago, and now I'm married with 3 kids.
Yeah, that's right. Yeah,
that's helpful.
Yeah, it's something that a lot of people avoid. It's obviously not fun to talk about. A lot of people just don't like to think about it at all. My wife included. It took her a long time to sort of get her instructions. It is inevitable. You cannot avoid it.
Nobody gets out alive.
No,
Yeah.
and it's much better to be planned. It's much better to have something in place because it does leave a mess, to be honest.
Yeah.
If you die without a will, it's messy. It's a lot easier if you have something in place, no matter who you are, no matter how little you have, it is always easier with a will. It's always manageable without a will, but it's easier without with one.
So clearly, best option is to see a solicitor, see an appropriately specialised solicitor.
Yes, I would agree.
But then, but then I've heard people say you can go to the public trustee and they can draft you a will.
Yes, very much.
And then also people talk about a will kit that sits on the counter at the post office and stuff like that.
Yeah. So I'll give you a horror story.
Go for it. Yeah.
Had one recently, earlier this year actually. There was a will kit that was done, and it was witnessed by two people at the pharmacy.
Cool.
They wrote their name, their address, and the date, but failed to sign. So they both put in their details, but didn't sign. So that needed to go to probate and then get requisitioned, which is when the probate register, the person who tries to give you probate, says, no, this isn't good enough, needs to be requisitioned. Then it needs to go before a judge, and the judge needs to decide whether or not it's a valid will or not. That whole process costs those executors approximately 10 to 12 grand, I think it was. And that's, that's relatively, that's right, a complete waste. So if you would spend $400, if that man had spent $400 to get a will done by a solicitor, that would have all been avoided.
$400?
That's what I charge for a single will. Okay. Yeah, I don't know. So that's pretty standard, I think.
Seems very good to me.
Yeah, you can get more than that, you can probably find cheaper than that too. I was driving past Lutwich Road the other day, and there's a sign out there saying wills for 150, and I was like, wow, I hope no one sees that. That is true.
It might just be a photocopy, you just write your name.
Yeah, that's right.
Maybe not too personal.
It's always important to get the advice. I mean, you need to know your options. Just doing a will isn't the hardest thing in the world. That the hard part is knowing what needs to happen, knowing what needs to go into the will to make sure it's relevant and stays relevant for as long as possible.
And also, I found when I did mine that it's the lawyer's understanding too of, well, that asset can pass to your spouse tax-free, but if you leave that asset to your kids who are over 18, then they will pay tax on it.
Yeah.
So why don't we mix this up a little bit and leave this one there and that one over there? That way everybody gets a better outcome.
Yeah, and it's important. Real property is very different as well. So it depends on how you own it. So it's important to know how that will pass. And you just like to know your options. It's nice to know what will go through your will and what won't. For instance, superannuation doesn't go through your will unless you make it.
Yeah.
So things like that, people aren't all that aware of. So it's always good to just have that consultation, know where you stand, and then it's up to you whether or not you want to go ahead at that point.
Yeah. With so wills are one thing where you're writing down, if I pass away or when I pass away, I want this to happen. I'll just call it power of attorney, but there's probably different levels of power of attorney that are if I lose capacity to act for myself.
Yeah.
So there's
two types of power of attorney.
They're a little bit more complicated when I was doing mine. There's a financial one, there was a medical one.
Yeah, that's it. Yeah. So there's a general power of attorney, which you only use for if you're going overseas or if you're not around for whatever reason and you're giving power to someone for financial reasons just for a short period of time. That's general. Most people don't use them. They're fairly uncommon in the industry. Enduring power of attorney is the other type.
Right.
And that is relevant while you're alive and after you've lost capacity, but then stops upon your death. So if you're in an accident, an enduring power of attorney is what you're going to need if you want to give someone else authority to either deal with you personally, financial and health matters, or personal and health matters, or financial matters as well. So you might have done one document that covers both financial and personal matters. Normally you appoint the same person anyway.
I didn't.
He did.
Yeah.
There you go.
Well, yeah.
Neil's obviously a hard client.
Well, true story. One of my brother-in-laws, who I said, I want you to be a financial
Right.
power of attorney.
Yep.
He said it was a good idea not to pick me as a medical power of attorney, because if I'm in front of him in the footy tipping, he's turning the switch off.
Yeah, that's right.
Yeah. So yeah, you know who you are.
Sometimes it's good to have someone who's decisive in that manner.
Yeah, that's right. Yeah. No, he knows his stuff. And so when people are, what did you call it before, administering the estate, what's the stage that people come to you or come to a solicitor?
Yeah.
Is it somebody in their close network has passed away? Is it always the executor that comes to you, or is it, how does that?
Sure. Yeah. So the executor is the person that needs to administer the estate. They're the one with the authority to do so. So normally they're the people that first see a lawyer. Beneficiaries would only really see a lawyer if there was some sort of problem with the estate, or if they wanted to contest the estate, for instance. I don't act for beneficiaries, I only act for executors. I'm against the policy of claiming against an estate, so I only act for executors when it comes to administering. So an executor will come to you normally after the funeral's been done and sort of those initial sort of taken care of. Yeah. Normally we need the death certificate to do anything, so you would normally wait until then before you saw a lawyer. A lot of people just give you an initial call saying, look, someone's passed away, I'm just letting you know that I'm probably going to need some help. And then we normally let them know what to do at that point. But yeah, it's always best to wait to the death certificate, so then we can actually do things. You rarely need to rush something in the estate. You normally can just sort of take your time with it, allow yourself to breathe, and then see a solicitor, unless there's something really pressing, but most of the time there's not.
Yeah, nice. Yeah. And I've the common saying is, where there's a will, there's a way, but I think in your form of law, it's where there's a will, there's a relative.
Yeah. That's right.
You say you don't advocate the challenges, which is good, but can everything be challenged? Like how do you protect yourself if you're doing a will going, there's somebody here that might come out of the woodwork, and can you do certain things?
There's two ways to contest. So
this is get real, okay? Get real with Neil. So that's the hard-hitting question for you, Tim.
Yeah. So you can claim that the will is invalid for whatever reason. So you can say that the person didn't have capacity at the time. You can say that the person was unduly influenced, or you can say that the will is a complete fake and someone's made it up and signed it. So that is the first way to contest the will, and that is a very difficult way, very uncommon way. Most people go to the second way. Second way is called a family provision application. So FPA for short. This is where a certain person can make a claim against your estate by saying that they have not received enough money and that they should have received money because they were dependent on you in some way.
Yeah.
Now, those people can be your spouse. Spouse is interesting in this term because spouse means your husband and wife, or it also means your de facto partner. So if you're living with someone
for 6 months,
2 years for estates. That's an important differentiation. For estates, it must be 2 years up before date of death, living on a continual domestic basis. So if you're with a boyfriend or girlfriend and you've been living with them for 2 years and then you pass away, then they are your spouse. Okay, so they can make a claim against your estate. If you don't have a will, they're also going to get the biggest share of your estate through the rules of intestacy. So spouse is an important word for estates. Also important about spouse is husband and wife. Only when you get divorced do they stop being your spouse. So let's say you separate. Let's say you separate, haven't gotten divorced, then you are still that person's spouse and will be regarded so for those purposes, intestacy and FPA. So spouse is the first person that can make claim against your estate. Second person is your child. Now, importantly, that includes stepchildren. So any of your spouse's children can make a claim against your estate. And spouse is the same definition as just before. Your husband or wife or your de facto partner. Any age, yes. Doesn't matter how old they are. Doesn't matter how sort of what relationship you have with them, they can always make the claim. That's the important thing. They can make the claim to frustrate your estate. They may not get very far with it, but they can always make the claim. And that's what I very much don't like about the system.
Yeah, got it. Yeah.
Last thing is dependents. So last eligible person is a dependent. Now this is a very strict process. So it's a dependent can only be a person who is under 18 who is dependent on you,
yep.
A person who is your parent who is dependent on you,
yep.
Or a person who is the parent of a minor child of yours who is dependent on you. So let's say that could be your ex-spouse who is the parent of your child.
Oh, yes.
They can make a claim if your child's still under 18.
Yeah.
So dependence, very strict criteria.
Wow.
Yeah, so it's really just your spouse and children most of the time, unless you have people that are dependent on you and are one of those three people.
Yeah.
So they're everyone that can make a claim. To be successful, they need to show financial need. They need to be able to establish that they need money from you and you didn't give it to them. That's not that difficult.
Oh,
yeah.
Oh, really? Christmas presents.
Well, yeah. So, I mean, if you own your own home, but you have a mortgage and then you have a bit of savings, you're probably going to be able to show financial need. You know what I mean? So it doesn't need to be someone who is completely on skid row. It can be comfortable people, just as long as they have some debt and aren't really comfortable.
Yeah.
So yeah, the financial need isn't that hard to get over. And then it comes down to a bunch of different sort of circumstances. So the size of your estate, your relationship with that person, whether or not they were dependent on you, whether or not you gave them money, gave them gifts, whether or not they helped you out financially. A bunch of different sort of things come into play.
It takes time, all this stuff.
Yeah, so basically you have 6 months after date of death to give notice of your claim. Then you have 9 months after date of death, so an extra 3 months to actually make the claim. Now the claim is done by a process of application. So you make an application to the court. Once the application's made, it's normally tried to settle straight after it. If you can't settle, you go to a thing called mediation. Normally they settle there. I've had only 2 that haven't settled at mediation in my life. And mediation normally takes the whole day and normally costs about 30 grand.
Good rate.
Yep. Oh, that's 30 all up.
Yeah.
Okay. And then trial. So trial normally takes 4 days. Yeah, you don't want to do that.
And I know from other discussions we've had before, Tim, that like some things that people can do, talking with financial planners and also with looking at their estate, is think about how assets are owned. So like I know you've said before, like the family home, if it's in joint names, then there can be an automatic transfer.
Joint tenants is the important term there. So so you can hold real property in Queensland in 2 ways. It can be joint tenants or tenants in common. Joint tenants is when you both own the property equally. And when one of you dies, the survivor automatically takes the property. That's joint tenants. That's the important one.
Yep.
Tenants in common, less common way to own property for couples, for married couples or de facto couples. But it's where you own a percentage each. So let's say you and I own property together. I own 25% of it. You own 75% of it. That 25% is going into my estate, goes through my will. Your 75% is the same. Your estate, your will. So if you have people that are contesting your estate, that 75% share will be subject to contesting.
Beautiful.
But if you are joint tenants, which is the most common one and the first one, the way we recommend normally, unless there's other issues involved, it won't go into your estate and will be avoided. Now, not going into your estate is also good if you don't have a will, because if you don't have a will, then it won't go into the rules of intestacy and will go directly to the survivor of it. The problem is if you don't have a will and you have a property in your sole name or as tenants in common, then your share needs to be split between your spouse and children. So then most of the time it's going to need to be sold.
Yeah.
And that's where things get really messy, because you don't want to have to sell your home
house,
and then have to hold money on trust for your minor children.
Yep.
So yeah, it can get very messy.
Yep.
So it's really important to know how you own your property if you own it with other people.
Beautiful, beautiful.
And to do that, you can look at the conveyancing papers that you have when you originally had it. If you can't find any documentation on it, there's a thing called a title search that we can do. It costs about $36. So if you're unsure and you need to know, that's the best way to do it.
What is, that's cool. What is probate? Is there an easy explanation?
Yeah, I did a video on probate yesterday.
Yeah, I might have seen it. That's my question to you.
So probate is essentially recognition from the Supreme Court.
Yep.
And it comes as a certificate. So it's a certificate with the court seal on it. It basically says that a will is final and valid, and it names the executor as the person with authority to deal with your estate.
Yeah.
Now, why is it needed? Probate is often required by banks and nursing homes when they are holding money over a certain amount. Normally between 20 and 50 is when they draw the line and say, no, we need probate. Now, why they want probate is in the past, they've given money out without probate. And then it was later determined that they gave it to the wrong person. And then they were held liable for giving those funds to the wrong person, and then had to give more funds to new beneficiaries in the new will. So it's all about protection. If you have probate, you can rely on the court's authority. If you don't have probate, you've got nothing to rely on but the will, and the will could be invalid for whatever reason. So that's why probate is often required.
Yeah.
And it is
so for insurance over 50 grand of life insurance.
Yeah, right.
If there's not a beneficiary.
Yeah, right. There you go.
Insurer goes, we want probate.
Yeah.
And everyone goes, what? He would have wanted to leave it to me, or she would have wanted to leave it to me. It's part of the process. I'm not sure I understand it.
Yeah, it's a very annoying process for a lot of people. It is it is red tape at the end of the day, and that's what it is. It's a process that needs to be done for ticking the boxes. That's right. Now, the other thing that it's important for is your executor. So let's say your executor has a will and they're named in it as your executor. If they act on that will without probate, and then it's determined later that that will was invalid for whatever reason. Right. So if it's later that there was a later will, for instance.
Oh, yeah.
So let's say you have a will and you name me as your executor.
Yeah.
And it says to give it to just one of your children.
Yes.
I give it all to him under that will. Then later on, it comes to light that you've done a will that was dated 2 years after it, and it says give everything to all of your children equally. I'm responsible for giving away those funds because I didn't get probate. If I'd gotten probate, then no one could sue me because I'd be relying on the court's authority that will was fine.
Oh, yeah.
And that's why probate exists. It's because we want to be able to tell the rest of Queensland that we are trying to make this will the last final will. So if you have a problem with that, you got to let us know. So that's why we do this thing called advertising, and we wait 2 weeks before we actually make the application, so people can come back to us and say, yeah, we do have a later will.
Yeah,
it's not a flawless system, but it's at least enough to try and sort of offer that protection.
Yeah, that's very, very good. Very good. Well, I've sort of come to the end of my.
Come to the end.
Yeah. Is there any hot tips? Any lawyers' insights? People could. Yeah. Always look for this or watch out for.
I mean, my hot tip would be always have an initial consultation. It's free most of the time, and it lets you know where you stand.
Yeah.
And then you know whether or not it is important to have a will, and you'll know what you're missing out on if you don't have one. The other thing we didn't talk about was guardianship. And I mean, that's one thing that a lot of people do worry about, is if you don't have a will, who's going to look after your children? It's not automatic. It doesn't automatically go to their grandparents or something like that. And if you have parents on both sides of your family or siblings, who's to say they're not going to argue or fight over who should look after those kids? So that's a very simple thing that can be put into a will, and if you don't have it, it gets very messy.
Yeah, well, there would be a lot more. I expect to be a lot more emotions charged around kids than assets. You would hope. Oh, okay, maybe not. But you would hope that.
Very wrong about that.
Right.
No,
Okay.
look, money is the ugliest thing in the world, and I see it every day. I mean,
Mm.
money completely ruins people's lives. They fight over it until there's nothing left, or until they get what they thought they wanted, and then they have nothing really.
So do it right.
Yeah.
Get advice.
Do it right the first time.
Do it right
Save
the
a lot
first
of
time.
mess, a lot of pain,
grief.
a lot of stress.
Yeah, very good. It's an old insurance saying, but maybe it's relevant. I think it is for the succession law, which is having these plans is about getting the right money in the right hands at the right time.
Mm.
That's what we've always said about life insurance: is the right money in the right hands at the right time. And it sounds that's the
Very good.
The right tie-in for introducing and closing off with Tim Henry from Henry Lawyers.
Thank you
And
very much. Yeah.
if you want to know more, look us up and
Get real.
and I'll direct you in the right way. Thanks, guys.